and welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. In this edition, we are going to take a hard look at the somewhat tricky but serious issue of whether there should be any checks and balances on the regulatory power, specifically the power of banking sector regulator, the Reserve Bank of India. The issue has come centre stage thanks to a series of developments in quick succession. The recent Supreme Court ruling on RBI's 12 February 2018 circular mandating reference to the NCLT under IBC if there is no resolution within 180 days of the date of default. Kotak Mahindra Bank taking RBI to court on the regulator's directive to reduce promoter Uday Kotak's stake in the bank, the NCLAT, National Company Law Appellate Tribunal, ruling that RBI cannot tell banks to classify their IL&FS exposure as NPA without the tribunal's prior permission. All this is a far cry from the days when the RBI's word was law. But do such instances risk undermining RBI's authority? Remember, RBI alone amongst financial sector regulators is not subject to any appellate authority, unlike other regulators like SEBI or the PFRDA or IRDA, where the Securities Appellate Tribunal (SAT) is the appellate authority. Joining me in the discussion are three experts: Jayan Gupta, founder and managing director, Stakeholder Empowerment Services; Hemendra Hazari, independent banking commentator, known not to mince words; and Anant Narayan of SP Jain Institute of Management and Research, Mumbai. Welcome to the show, Mr. Gupta, Hemendra, Anant. Let me start by asking for a brief opening comment. Is questioning the regulator a democratization of power and hence a good thing, or does it risk undermining its authority with possible serious adverse consequences? Let me start with you, Hemendra.
In my opinion, I think any individual who is regulated or any entity which is regulated in a democracy definitely has the right to take the regulator to court if that individual or that entity believes there is a genuine disagreement. However, if the court were to overrule and in favor of the entity which has taken the regulator to court, then that judgment would definitely undermine the credibility of the regulator. And therefore, I think it is incumbent on the regulator to be, so its actions to be seen as, very fair and impartial. So I think in a nutshell, everyone has the right in a democracy to take the regulator to court. But if the regulator loses, then its credibility in the system as a regulator does definitely come under a question mark.
Mr. Gupta, when does questioning become defiance? And who is best placed to decide? Courts, an appellate authority, or in the case of the banking sector, given its implications for the larger economy, the banking sector regulator itself, the Reserve Bank of India?
See, I would agree with Mr. Hazari in the sense that there cannot be any system in any economy where an organization is not subject to question. If RBI is a regulator, we cannot assume that RBI will be right all the time. So therefore, if there is any issue between RBI and the regulated entity, it has to be first resolved amicably between the two, talking to each other, convincing each other. If there is a failure, then it got to go to a court of law and something. And I certainly don't agree in the sense that authority or credibility goes down, because if you have seen in the last 1 decade, many of the SEBI orders have been turned down by Honorable SAT or High Court and Supreme Court. It has not dented SEBI authority. What it does, it puts SEBI and its regulation on the drawing board again, and reform comes. See, the reforms will come only after there is a problem or there is a mistake and you go back to the thing. RBI has to, I have been saying umpteen number of times, RBI has to revisit its regulation and see what is there, because I believe law is servant of the logic. Logic is supreme. So RBI must say that whether its regulation which are in the current form are logical or not.
Anand, now let me come to specifics. How do you read the recent Supreme Court ruling? As yet another example of RBI's authority being disputed, or as a technical, legalistic interpretation of the legitimacy of the February 12th circular in the light of Section 35AA of the Banking Regulation Act? Anand?
Well, Mythili, first of all, the Supreme Court judgment against the RBI circular, Feb 12th circular, is clearly a bit of a shock for old timers like me. We're used to looking at the RBI and regarding it as the absolute benchmark for professional, thorough jobs, and to see its authority being questioned by the highest court of the land is not a pleasant sight. And one can't help but worry that the huge and enormous credibility and equity and goodwill that the RBI enjoys has maybe been tarnished a bit by this particular verdict. But if you step back, I'm hoping that this is the vestige of what happened in 2018, where clearly there was a breakdown in the communication between RBI, the government, and the entire financial ecosystem stakeholders. That led to a lot of unpleasant events, culminating in the resignation of Dr. Patel. And maybe this is just the last vestige of that, where clearly the government, the RBI, and other stakeholders were not speaking to each other enough. Hopefully that's behind us. In that sense, I think it's great that we have Governor Das right now at the helm of affairs. Last bit, I'm also hoping that this entire mess around the power sector, which I guess triggered this entire court case in the Supreme Court, also gets resolved. Not necessarily by shooting the messenger of RBI, but actually resolving the issues of the fuel supply agreements, the power purchase agreements, and getting DISCOMs to pay the producers on time, etc. The real reforms which are required.
Hemendra, now let me turn to the specific case of Kotak Mahindra Bank. Admittedly, the RBI's extant strictures on dilution of promoter stake came after the license was initially granted. But even so, should RBI be the final arbiter? And how much forbearance it is given to Kotak? Given all that, does the latter stance smack of defiance?
In my view, Kotak is a brazen act of defiance against the RBI. You know, this notion which Mr. Uday Kotak propagates, that when he was given the license, the shareholding was the minimum had to be 49%. To me, what he is saying is that, you know, whatever direction had been given at that time is kind of engraved in stone and cannot be changed. I think any regulator, like any law, has the right, based on subsequent events, to change the norms. And the RBI has been mandated by Parliament to protect the depositor's interests, which is far greater than the shareholder's interest. Two, it has the mandate of financial stability. And therefore, in my view, RBI had every right to change its norms, and they subsequently brought it down to 15%. Now, the thing is, RBI unfortunately gave Kotak repeated relaxations, and therefore Kotak thought it was his right that he could continue to get, you know, relaxations. And when the RBI finally put its foot down rather belatedly, he took the RBI to court, which is fine. I don't mind that, that's his right. But in my view, RBI by law can, you know, force a promoter to reduce its stake, and that is what, you know, Kotak Bank is contesting in the court, and we have to see now what the court will decide.
I would agree with you, Hemendra, that the RBI has a right to frame policy and it should be evolving. But Mr. Gupta, it would appear that Kotak is in fact splitting hairs by arguing that a preferential share issue serves the objective of diluting the promoter's stake, because we all know that preference shares carry no voting rights, and ultimately we are talking about voting rights. Moreover, if Bandhan Bank could comply, why not Kotak, Mr. Gupta?
Okay. First of all, I would want to make a disclosure that I don't own a single share of Kotak directly. My mutual fund could be holding, I do not know. But I would go one by one, take the issue. First of all, I agree with Mr. Hajari that any regulator has a right to change the policy. But the change in policy has to be logical. It cannot be any illogical change. If you look at the history, the RBI changed and asked the minimum promoter holding to be increased from 40 to 49%, and it was said that it is to give a level playing field. That means FDI was permitted 49%, so RBI said. Now that level playing field continues, but RBI has said now 49% becomes 15%. Okay, I agree for 1 minute that 15% is right. Now when you say voting right is 26%, then where is the sanctity of 15%? The other issue is this, from where the wonder figure of 15% has come. I don't find any rationale anywhere from where the 15% has come. The other issue is this, that any regulation has to be based on some empirical evidence. Now, where is the evidence that a shareholding less than 15% of the promoter is good or bad? There is no empirical evidence. And if you look at the history of this thing, RBI itself is to be blamed on the preferential share or voting share, because RBI has been using the term voting capital and paid up capital interchangeably without any difference. And then you see, look at what happened. If you, thanks to the wire, I could read the RBI's reply. Kotak was asked to reduce equity under 2005 guidelines, and in 2016 the guidelines that came have repealed the 2005 law, and 2016 guideline very clearly says in a proviso that if licensing conditions permitted higher equity, it will be permitted. So, I do not know where RBI is confused. Either right hand of RBI does not know what they are doing, or left hand does not do. Now, come back to other issues. Empirical evidence, if you look at the 12 cases which has gone to NCLAT, you will find that there is only one case which is in the equity between 25 to 50%. Rest is on the two extremes, very low promoter equity or very high promoter equity. So,
yes,
I don't have any.
Come to those, sure.
Yeah.
But we're not talking about corporates, Mr. Gupta. We're talking about banks. So just let me restrict the discussion to banks and the regulator in the banking sector. But let me move to the next issue: loan classification. Should the NCLAT interfere in what should be seen as a strictly technical issue? And if it does it not run the risk of introducing discretion in loan classification? And that could be very dangerous. To my mind, the NCLAT as a quasi-judicial body should only be concerned if there is a point of law, not otherwise. Anand?
Oh, I completely agree with you, Mythili. I think it's best to leave loan classification and the quality of assets as far as banking balance sheets are concerned with the RBI. Getting the NCLT to start pronouncing judgments on what banks should be doing in respect of asset classification is a completely slippery slope which should be avoided. And I guess you're referring to the IL&FS case where there's been a standstill in payments from each of the entities within the IL&FS family. At the same time, NCLT is saying that you can't classify them as non-performing until they actually opine on what needs to be done. I think that's a case of the NCLT wanting to have the cake and eat it too. You can't have it both ways. If you're confident that the money will come back, then allow those entities to start making the payments. If you're not confident, therefore you have put a standstill out there, then the law has to take its course and the right recognition of asset quality has to come through. So absolutely agree with you. I think RBI should put its foot down and ensure that areas such as banking regulation and banking asset classification remains its realm, doesn't go out to other entities.
Oh, absolutely. And Hemendra, what is your quick take on who should have the final word on loan classification and also on the bank's Feb 12 circular? Justice Mukhopadhyay of the NCLAT has pulled up the RBI, saying that the bank has made it a prestige issue. I must confess that while I am with the RBI on loan classification and hence on provisioning, I do think the bank has gone a bit overboard with insistence on referring certain specific NPAs to the NCLT. Once a loan is fully provided for, that decision what to refer, what not to refer, isn't that a decision best left to the commercial judgment of lenders? Would you agree, Hemendra?
See, the NCLAT decision is a complete encroachment on the RBI's authority regarding loan classification, especially for an NPA. Now, otherwise, you'll have this situation where RBI puts out a norm, but to classify the NPA, you have to go to a court to get its permission, which is absolutely absurd. And I think it is very important that the NPA definition has come about on the very basis that if you are in default of 90 days, it will be NPA, period. It should not be, selective to a couple of industries or couple of companies. And therefore, in my opinion, the RBI has complete authority on the identification and classification of a loan account as performing or non-performing. And I don't think, therefore, the NCLAT has taken an appropriate and mature decision in this matter, because if it were to be, succeed, then it will completely undermine the entire income recognition norms that the RBI has put forth.
Absolutely, and this is a technical area, so I entirely agree with both Anand as well as Hemendra on this. And I'd like to get Mr. Gupta's views also, but I'm afraid it's time for us to slip into a very short break. But please do stay with us, we'll be back very soon. Welcome back. You're watching Macros with Mythili, and I'm in discussion with three experts on the issue of whether there should be any checks and balances on the powers of the banking sector regulator, the Reserve Bank of India. Mr. Gupta, before the break, I think both Mr. Gupta, both Ms. Hemendra as well as Anant and I all agreed that on the technical issue of what is NPA, what is not NPA, income recognitions, these are issues that are best left to the Reserve Bank of India, and the judiciary should not interfere in this. Would you agree? Also, I have a question for you. Does the need for an appellate authority really arise when there is discretion that comes into play? For instance, in the case of power sector assets, most of us would agree that these are far more critical to the country than the airline. We're talking in particular of jet. And yet banks, presumably with the implicit approval of the Reserve Bank of India, have now come to the rescue of jet, but made no such case in the case of the power sector. So are these issues where discretion comes into play, and there one can argue there is a case for an appellate authority or maybe even the judiciary, but not in purely technical issues? Mr. Gupta?
I would say that there cannot be any difference of opinion as to what is an NPA and what should be done to NPA. It has to be absolutely within the domain of RBI, period, as I say. But then the issue is that why NCLT is coming into being and something, I do not think NCLT has any role to play. But then the question that comes, that what is in the larger interest, because every regulation is a process to achieve a larger interest. Now, what happens in case where a company goes to bankruptcy and something, and it really damages its operation, its reputation, whatever happens. So any scheme, anything that is done, it has to be done in the larger interest of the society, larger interest of the public. Now, in case by technically qualifying a asset to be NPA and it harms the larger public interest, but in a short term it can be revived or it can be changed, I don't think there is any harm, although it has to be done very transparently and not selectively, that you are my relative or you are a government company, then it will be done. No, it cannot be done. But I would say largely appellate authorities like NCLT should refrain from interfering into the domain of RBI.
Oh yes, absolutely. The problem is judicial overreach in this country is very common. But Anand, our disputes and disagreements, partly because the RBI really does not involve practitioners, and I repeat the word practitioners, adequately file framing policy. In fact, the committee that recommended use of external benchmarks, for instance, consisted entirely of RBI officials who frankly lack practical banking experience. And that creates a great deal of problems for the regulated entities. Anand?
Mythili, I'm not sure I agree with that. It's possible that RBI doesn't have practical experience, but my own sense is their job is to act as a watchdog. Their job is to ensure and be the right messenger and ensure that the rights and the duties of the depositors are protected. After all, you have to protect the banking system and the whole army of depositors who fund that banking system. Now, in doing so, they are acting as the messenger and saying, listen, there is a problem with a certain set of loans and advances. Make sure you please recognize that, provide for that, and ensure that there is no trust deficit on the asset quality of your overall books. They are doing their job. What does that job involve? And particularly after the passing of the Insolvency and Bankruptcy Code, a fantastic piece of legislation, the weapons available for the financial services ecosystem to get back money from the people who lent money to has been strengthened dramatically, and RBI is only playing into that. What is the RBI saying? The moment there is a default, you have 180 days to figure out some way of restructuring it or curing it. If you can't do that, please go to NCLT. What does NCLT have to do? It gives 180 days plus an extension of 90 more days to find a resolution. If you can't find that, then go through a liquidation process. In all, you have 1 year and 3 months available from the start of the default to try and find a restructure. Don't tell me that we can't find a solution or a restructuring to the problem in that time period. I agree, for instance, power, you made a very good point. What are the issues in the power sector? You have problems with fuel supply agreements, you have problems with DISCOMs not paying up on time, you have problems with power purchase agreements not being in place or being litigated. All of these are egregious issues. Find a resolution to that. Or if you think it will take time, then restructure the loan. Nobody is saying, close down the power factories and therefore put people out of work. Now that problem and that solution doesn't lie with the RBI. That is for the entire ecosystem, including the government, including the companies, the promoters, to find a solution to. Now, why are we shooting the messenger for saying there's a problem with the loan? Let's open our eyes, recognize there's a problem and find a solution which, as Mr. Gupta was saying, protects the larger interests of the country.
Oh, absolutely. And the only thing is where the RBI tells the banks that these are the accounts 1, 2, 3, 4, 5, which you must necessarily refer to the NCLT. Because my point is that once the bank is fully provided for that loan, then maybe it should be left to the lender's discretion because it's fully provided for. So safety is not an issue as far as the RBI is concerned. But Hemendra, could wider consultation be the way out? The RBI does consult, but we seldom see the bank modify its directions based on the feedback from practitioners. Of course, under the new governor, we do see a welcome change. The bank, in fact, has kept his directive on the use of external benchmarks on hold. But till fairly recently, the bank was very adamant, unlike SEBI, which used to engage in much larger consultation. RBI tended to be a bit of an ivory tower. Would you agree with that, Hemendra?
See, when it comes to regulator, you have to be very careful about consultation. While consultation is always welcome, it should not result in, the regulatory capture. And we've seen this even with the US Federal Aviation recently with Boeing. So that's the whole point. When does consultation become regulatory capture? Because no doubt the regulated entities will always raise a huge hue and cry about consultation, but actually they are raising it because they want to capture regulation. And that is the tricky part where one has to clearly draw the red line, because this is their ultimate objective. They want to control the regulator. And this is what has been extremely dangerous. We have seen this in telecom in this country. We've seen this in various other sectors. And therefore, I'm rather wary of consultation, because consultation, I believe, results in regulatory capture.
Oh yes, we need to guard against that, and regulatory capture is very common in capitalist societies. But Mr. Gupta, the FSLRC, the Financial Sector Regulatory Reforms Commission, in fact had wanted a financial sector appellate authority to cover all financial sector regulators, including the RBI. But this was vehemently opposed by the Reserve Bank of India. Perhaps rightly so. But does it appear in the case of what we are seeing recently that there might be such a case? Currently, RBI's decisions can only be appealed against in the High Court or the Supreme Court. So is there a case for an appellate authority to cover RBI also, Mr. Gupta?
See, I would say logically there cannot be a situation where 10 regulators are subject to an appellate mechanism. The 11th regulator should not be subject to appellate mechanism. So logically there should be done. But I would disagree with Mr. Hemend Hajari respectfully when he said that consultation leads to regulatory capture. I would disagree for the simple reason, if you have an example of SEBI, where SEBI has consultative mechanism for each and every regulation that it frames, and I don't find there has been any regulatory capture of SEBI on anything. The second issue is this: when you say that there will be no public consultation, you are only looking at what you know and what you think. At least listen to somebody. It is always up to the regulator that after public consultation, the regulator decides what it feels it is right. But shutting the public opinion form is very, very bad. And I would say RBI track record of transparency is very, very poor as compared to any other regulator. If you recall, in 2015-16, they had called for comments on bank licensing norm. They came up with the final norm, but they did not disclose what type of public comment they had received. Whereas SEBI, whenever they did public consultation, they publish the record. So I would say shutting the communication is never an option.
Okay. Okay. Anand, Mr. Gupta gave the example of SEBI, and that is a frequently quoted example. But here I would disagree, because I would think that the RBI is different from other regulators, because ultimately the issue of too big to fail, financial sector stability, etc., these are issues that concern the RBI, and SEBI never comes to the rescue of any capital market player. There's no taxpayer money involved. Would you think that makes a very critical difference, Anand?
Look, it's a tricky subject, Mythili. I do see the logic behind having an appellate authority to review decisions, because after all, regulators are human. They can make mistakes as well, and there has to be a redressal mechanism, not necessarily going to the courts. But here is the tricky part. If you do have an appellate authority for the RBI, they have to be independent, which means they have to be another RBI. What you have to guard against is the executive being in charge of the appellate authority in some form or the other. As it is, the executive has the say over, the final say over the regulator, because of the nature of our laws in our country, including Section 7, the board of directors of RBI, etc. What you don't want is the patient deciding what medicine he or she has to take. And so and so medicine is too bitter, I don't want to take it. This message is bad, I don't want to see it. That is what you want to avoid. So to me, as things stand, they are good enough because you're achieving that independence that RBI normally has on a de facto basis. You have to avoid the regulator or the industry or the regulated deciding what regulations will be, which is what Hemendra is talking about. The need to have a robust debate about individual decisions, including what Mr. Gupta said, some of the decisions don't seem to be backed by research. That robust debate, the fourth estate has to take up and do it robustly.
Okay, Hemendra, one quick last word from you.
I think by and large, because the issue really has been RBI has formed in 1934. At that time, it was given absolute power, and it has evolved that all the other subsequent regulators in the economy have come up at a much later stage. And at that time, of course, they've decided that there will be an appellate authority. Obviously, for a regulator, for any body or any entity, to have somebody inserted at the top is bound to be resisted. That is but natural. But I think overall there should be, there could be considered an appellate authority. But true, the financial system, depositors' money, they deal with the financial stability of the entire economy. All these are very crucial and complex issues. And therefore, whether the appellate authority will have that type of expertise that the RBI does when it reviews the RBI's decision, that has to be seen.
Absolutely. So, tricky question, no clear answers, but I think it's important that we continue to debate the issue. Thank you so much, Hemendra, Anant and Mr. Gupta, for joining me in the discussion. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, it's thank you and goodbye from all of us at TT Now.